The next section of charges that are eligible for expungement under the expungement statute are charges that have been withdrawn, nolle prossed, dismissed, or not received any kind of finding of guilt. So, typical scenario would be a husband and wife get into a fight, they're charged with simple assault against each other, maybe a misdemeanor 3 simple assault. They go to some counseling, they reconcile, they decide to stop having so many fights, and they go to the preliminary hearing. Maybe they both have defense attorneys, and they talk to the reasonable police officer and they say, "Officer, these people don't have any prior record. They had a fight. It's a stressful time in the economy. They are going to counseling. They both don't want to go forward and testify against each other. Can these charges be withdrawn?" If the officer agrees, then the matter is withdrawn by the Commonwealth. And so after charges have been withdrawn by the Commonwealth, then an expungement petition can be filed, because whether it's fair or not, the fact that the husband and the wife have been charged with simple assault will remain on the public record. It will show no conviction. It will show the charges were withdrawn, but it will show as a simple assault. And unfortunately, we all know that employers and just general people these days, if they see an allegation, they think it's a conviction and it's not, and then you end up explaining something that should never need to be explained. That's why non-convictions need to be expunged. Now, the same case could go in front of a judge for a hearing, maybe because the officer won't agree to withdraw the charges. So the judge would start a hearing and call the wife to testify against the husband, and she might say, "I don't want to give any testimony because I can't give any testimony without giving evidence against myself." And the judge might say, "Well, okay, well then you're excused." And then the husband would be called and asked, "Can you give testimony against your wife?" And the husband might say, "I don't want to give any testimony against my wife because I can't give any testimony without it being used against me." And the judge might say, "Okay, well then you're excused." So the Commonwealth brought the case, and I've heard the fact that there is no evidence, and so I'm going to dismiss the charges. So the dismissal comes from the judge of the court, not the Court of Common Pleas. The dismissal comes from the magisterial district judge because the Commonwealth couldn't support their burden of proof, but wasn't willing to withdraw it. Nonetheless, there's no conviction of guilt, and so that charge can be expunged upon petition. Another subcategory is nolle prossed. I get a lot of questions about this because it's a weird word. Nolle pros, nolle prosse, nolle prosequi. It's a Latin phrase meaning not prosecuted. It means that the Commonwealth has the burden of proof to move forward. They didn't move forward for whatever reason. The case was nolle prossed. Maybe the Commonwealth isn't comfortable withdrawing the charge, and instead they say, "We're not prosecuting it." There's very little legal distinction there. It results in a non-conviction, and therefore it's eligible for expungement.